So asking women to march in lockstep with one philosophy is exactly the wrong kind of message we should be sending to women, and especially to young women. What I hear so often from the left, many of us on the right do, I would say probably Senator Blackburn hears this, many others hear this, that because we don't hold the same views that those on the left do, we shouldn't be serving in the roles that we are in. And that's what the left is projecting on you, is because you are not lockstep with what they want to see in their nominees, that you aren't worthy of serving on the bench. I don't believe that. I don't believe that. And that shouldn't be the litmus test for the Supreme Court. And frankly, it shouldn't be the litmus test for any woman in any job. Any woman in any job. Diversity of thought and an ability to pursue her dreams is exactly what the women trailblazers of the past fought for. If the suffragettes hadn't been willing to go against the men of their time, certainly none of the women sitting on this dais would have the opportunity to question you today. So what would you say to those that claim you are not an adequate replacement for Ruth Bader Ginsburg because you do not march in lockstep with her judicial philosophy?
Well, I think that judicial philosophy is an appropriate and an important topic for this committee to explore at the hearing. And I think each of the senators has a responsibility when a nominee comes before you to ask what the judicial philosophy is. And I think disagreeing with the judicial philosophy that I or any other nominee had is perfectly admissible grounds for voting no, because you may have a different vision for what a justice or a judge is to do, and so I have no problem with that. I mean, I think that is how the senators on this committee have viewed their role, and so to, on philosophical or, jurisprudential grounds, I mean, I think that's part of what, or, a lot of what this hearing should be about. I think that there's room on the court, and I don't think this just in terms of the women, but I think this for all members on the court, there's room for different approaches to the Constitution, and I think those approaches shouldn't be broken down into partisan boxes because judges are not partisan. They do get appointed and confirmed by the political branches, but judges don't have campaign platforms, and they no longer associate, as I've said a number of times through the hearing, judges stay out of politics. So their jurisprudential philosophies are not designed to yield particular results. So I think there's room for different jurisprudential philosophies that, by the way, even when they start and approach texts from different ways of thinking about it, sometimes yield the same result. It's not necessarily the case that two justices who, one being a pragmatist and one being an originalist won't end up at the same place. They just might get there a different way. Or even originalists, I mentioned yesterday that, there are many who identify themselves as progressive originalists. So originalists, could start at the same place, and, I suspect that, they would disagree, end up in different places, and I've given examples of that. So I think there's room, and it's good and healthy for different approaches to the Constitution and to have debates about that.
Thank you. I really do appreciate that answer.